Our top story. In heinous crimes, can a juvenile be tried as an adult? In 2017, you will well remember a 16-year-old student at Gurgaon's Ryan International School had slit a 7-year-old's throat. Why? Because he wanted the school exams and the parent-teacher meet that would follow to be postponed. Since 2017, that is in the last 5 years, there has been much legal to and fro as to whether the 16-year-old should be tried as an adult or not. When the matter reached the Supreme Court this July, it asked the Juvenile Justice Board to once again re-examine the boy. Today, the Juvenile Justice Board has said that the boy can be tried as an adult. Even in their initial assessment, the board had said that the teenager had sufficient mental and physical capacity to commit the offence, and he had the ability to understand the consequences of his action. 7-year-old Prince's father and the CBI that is investigating the case both wanted the killer to be given a harsher punishment, but the 16-year-old killer's family had moved one court after another opposing the move. Now, under the Juvenile Justice Act, a juvenile can be sentenced to a maximum of 3 years in a reform facility. Now, when tried as an adult, only the sentence can actually be made lengthier, but there is a bar on life imprisonment and death penalty. Let me go across to my guests who are joining us this evening. We are even opening up our phone lines on that question. In heinous crimes, should juveniles be treated and tried as adults? My guest this evening, Abha Singh, is an advocate joining us. Meenu Padha is a lawyer. She's also a women and child's rights activist joining us on the broadcast. Shashikant is a former DGP of Punjab. He joins us on the broadcast. And Geeta Luthra is a senior advocate. Abha Singh, I'm coming to you first. The question has been hanging ever since the time of Nirbhaya. Nirbhaya's the juvenile person accused in Nirbhaya's horrific rape and killing walked free with a sewing machine. He was tried as a juvenile. After that, every heinous crime that has been committed by a juvenile, demands have grown that rules need to be streamlined, and in heinous crimes, juveniles need to be tried as adults. What's your view specifically as regards what happened in 2017?
See, in fact, the courts have been very clear. There have been judgments saying that any juvenile who's in the age group of 16 to 18, and if he commits a heinous offense as murder or rape, should be tried under the Indian Penal Code. I stand by it absolutely. When you can commit such an heinous offense, why should you be protected under the juvenile law is my question. In fact, if you go by the NCRB figures of 2021, around 31,000 cases of crime against juvenile were registered, and of that, 76.2% were in the age group of 16 to 18. That makes it 28,000 juveniles had committed who committed offences were in the age group of 16 and 18. And the IPC sections were murder 302, 306, attempt to murder, kidnapping, rape. So when they can commit such offences, why should you protect them? Why should there not be justice for the victims who suffer these harrowing cases like Nirbhaya? They say the juvenile who raped Nirbhaya, the teenager, was most brutal. He was the one who had inserted the rod inside her. So why should they go scot-free with just 3 years of in a shelter home? I absolutely agree. And I'm happy that the courts have finally said that if you commit a heinous offense, and world over, why 16 to 18? There are certain countries in the West where if you are 12 or 14 and you've committed a heinous offense like murder or rape, you are tried under the Indian Penal Code or the law which is there in that country. So definitely, if you have committed a heinous offense,
but
you should be given life imprisonment. Yeah.
Okay, Abha Singh, help me understand this. I may have got it wrong, but my research tells me that even if a juvenile is tried as an adult, all that will happen is increased imprisonment. He can still not be given death or life imprisonment.
See, increased imprisonment is still better than the 3 years which goes in a shelter home. So definitely, and now with under POSCO, under other laws, if you see, life imprisonment means as long as you are a good life, your full life. So that is good enough. Why should we go for death penalty? Ultimately, how many death penalties are executed? Most of them get a waiver by the president. But if you're tried under the IPC, at least, you know what is happening in Mumbai, at least I've seen as a lawyer, that a lot of Supari killings, these young boys who come from UP, Bihar, or these states, the underworld is using them to commit murder because they know they would go scot-free, and with barely 3 years of imprisonment. So even these juveniles are being misused by the underworld. So it is necessary that they get the same punishment which goes under the normal law for other adults.
Geeta Luthra, how can you oppose that argument? Look at what has happened in Hyderabad. It happened this year itself, where a 16-year-old is gang raped by 5 boys. 4 of them are juveniles. One of them is an MLA's son. The other one is a nephew. They knew exactly what they were doing. They knew the consequences of their actions. Why should they be tried as juveniles and not adults?
So the material question is what you've asked yourself. Do they know the consequences of their actions? And of course, as a society, we are responsible for not ensuring that we educate our children as well. And there is a huge criminology debate here. The criminology debate is, do we know that these children know what they are doing? What they are doing is heinous. What they are doing is, in layman's language, unpardonable. But the question is, when we are not talking as laymen, as we are talking as people whose purpose is not only to punish juvenile, but also to take care of reform, then the question is, should such juveniles be punished? Do you have a juvenile justice board which is trained to the extent? And I feel I have issues even when this law was amended, that how much studies did we do? Did we have psychiatrists, top psychiatrists, psychologists involved? Did we have people who had gone into the psyche of children? And one question that was asked at that time and which was not answered, which was asked by psychologists and psychiatrists, is, have we done enough of a study? And according to me, there was, of course, there is this issue that it cannot mean that children are, because they are children, they are forgiven for everything that they do. But they are tried as juveniles. And if they are tried as juveniles, and if we have reform homes that can work to improve the psyche of these children, we can have reform homes that look at why this child did something which was morally so heinous and so unsaid.
Okay. So Geeta ji, you're essentially saying that everyone deserves a second chance, especially kids.
No,
my whole point is, are they really kids? Are the 4 boys who gang raped the 16-year-old in Hyderabad in a moving car all across town, are they children? Is a 16-year-old who slit the throat of a 7-year-old so that his parent-teacher meeting could be postponed, is he really a child? Because this is what the assessment, you raised a question on whether the board is even qualified to make assessments like this. Well, this is what their initial assessment said. Now, you can always question that if they assess the boy now at 20 or 21 years, because since 2017 to now, the boy will be either 20 or 21, they may not get a correct assessment. That is an argument that you can make. But even their initial assessment had said that the teenager had sufficient mental and physical capacity to commit the offense, and he had the ability to understand the consequences of his actions. Therefore, Meenu Padha, I want to ask you, Geeta Luthra is saying if they can be reformed, why not?
No, I think I'm completely disagree with ma'am. Because obviously they are, in such a capacity that they can understand everything what they are doing, especially if I talk about the age group of 16 to 18. And I would like to share one thing, that recently Cabinet approved amendment to the Juvenile Justice Care and Protection of Children Act also, Act of 2015. And before the coming of this act, as we all know, that we had the Juvenile Delinquency Law and the Juvenile Justice Care and Protection of Children Act of 2012, in which one of the accused, we are all aware about the Nirbhaya case that has happened in 2010. As you already discussed, that one of the most serious perpetrator was the juvenile, but he has been given the 3-year imprisonment only, and later he has been fled away. So after that, there was so much hue and cry after this 2012 incident, the Nirbhaya gang rape case, that obviously a person who is between the age of 16 and 18, he should be punished like an adult. But unfortunately, in our country, a person who is below the 18 years of age is considered as a child till date. But as in our country, post facto law cannot be implemented, and that is why this Juvenile Justice Care and Protection of Children Act of 2015 came, which allowed for the trial of juvenile in conflict with law, which comes under the age group of 16 to 18 years, and as adult for heinous crime. That led to 7 years of rigorous imprisonment, and that will be treated as an adult. Now, this cabinet approved two important things in this new law, that is the Juvenile Justice Care and Protection of Children Act of 2015. One, they have differentiated the two crimes. One is the heinous crime, second is the serious crime. That is very important. The crime has been differentiated in these two groups. Earlier, there was a blanket category of heinous crime, like the crime who are punished, on which punishment should have the maximum sentence of 7 years or more. But now there will be two categories of crime, as I already told. One is the heinous crime, second is the serious crime. So, heinous crime, punishment of the crime should not only have a maximum sentence of 7 years or more, but also a maximum sentence of 7 years. In heinous crime, crime like rape, like sexual offenses. So, I think they are, enough capable of understanding what they are doing. So I definitely am in favor of this thing, that those who are in the age group of 16 and 18, they should be punished like an adult, not as a child, if they are doing any heinous crime.
And very quickly, Meenu, before I take my first question, what did you say was the maximum sentence for juveniles who have committed a heinous crime?
That is a 7 years. 7 years of imprisonment should be given to the person. Not maximum. Sorry, I'm really sorry. That is minimum is 7 years of imprisonment, and maximum is up to life imprisonment, of course.
Okay.
Yeah.
Okay. Anil Bedi is on the phone line with us, our first caller. Anil, please go ahead.
All the children or these minors, they should be treated at par with the adults. And why should they be given a preferential treatment, for heinous crimes? In any case, they have murdered somebody's child or somebody's loved one, and they should be made to stand in a court of law in the same terms as an adult. So, in fact, this is actually a loophole which is being exploited by the lawyers.
Okay. Shashikantji, please come in here. You've been a former DGP of Punjab. And while Geeta Luthra has said that if we have decent reform homes, why not give these boys a second chance, etc., etc., given the nature of crime that was committed in 2017 at the Ryan International School in Gurgaon, the nature of the crime that was committed in Hyderabad, where 4 minors have gang raped a 16-year-old, whether we go back to what happened with Nirbhaya and her, and her juvenile rapist / killer walking free with a sewing machine, there is anger. These are not kids. They understand exactly what they are doing, and they know the consequences of what they are doing.
Well, to start with, I'll say that I'm not a legal expert like co-panelists are. I'm a policeman, and my experience and whatever I'm going to say is based on my practical experience. To me, what is most dangerous thing for the society is a criminal mind. A criminal mind which can think over, plan, act, or enrage. So accidental actions are certainly, yes, juvenile is a juvenile, he should be treated like that only, no problem. But if there appears that he has a criminal mind, like one of these legal ladies were saying that psychiatric evaluation and all those things, that's very important. My experience all along, whether it's kids or adults, is that the same thing which I said, criminal mind. We have to ensure if we can reform. Again, I'm a firm believer in reformative theory. A person should be reformed if he can be reformed, if she can be reformed, why not? But if a person is beyond reformation, उसको अगर सुधारा नहीं कर सकते हैं, then I think that yeah, that's a serious thing. Like the
But
lady
who
is saying
makes
that,
that? But who makes that decision?
serious offense and
But who makes that
absolutely
decision?
brutal
Who
kind
takes
of
that
offense.
call?
Beg your pardon?
I'm saying,
I
who
couldn't
makes
get
that
it.
call? Who takes that call?
This call
Are they
has to be
reformable?
taken.
They are not
This,
reformable.
this,
Who takes
this
that call? And it's
this
very
call has to
subjective.
be. This call has to be taken by the juvenile board, and like one of the madams had said, yes, you should have a psychiatrist. There has to be that kind of evaluation. If the child can be reformed, why not? I believe in this thing. The person should be first attempt should be to reform. I or any other person is not capable. Like a psychiatrist, psychologist, they can do it. They should be on the board of this juvenile board, juvenile justice board, and they have to see if we can reform a criminal mind which is still growing. But again, I'm a firm believer that whatever happened in the Nirbhaya case, that particular person, sorry, I'm trying to restrain my words, needed the harshest possible of the punishment. That's not done. Thank you.
But why just the Nirbhaya case? Why not? No, why not the harshest punishment, Abha Singh, for Prince's killer? After all, when you talk about a criminal mind will plot and plan a murder, right? In this case, that is exactly what the 16-year-old did. He carried a knife to school. He had a motive. He had an aim, and he found a victim, and he did what he wanted to. Now, if this is not a criminal mind, what is a criminal mind? In the case of the Hyderabad rapists, they knew exactly what they were doing. They abducted a girl, they took her all around Hyderabad in a moving car, and they repeatedly gang raped her.
Absolutely, Shreya, I agree with you. In fact, for the criminal justice system, there is something called deterrence. And deterrence comes only with strong punishment. We may talk of reformation, but the main part of a criminal justice system is punitive part, where deterrence, why do we talk of death penalty? Because it gives a message to the society that if you're going to commit a heinous offense, the message is that we are not going to take it lightly. So that is required because the message has to go. At least after Nirbhaya, people got the message that if you're going to commit a heinous offense, you are going to be penalized with a strong action. So I think, because you rightly said, when mens rea is there, if it is planned criminally, if you've got a 34 of IPC which says where a group of people have planned a case out, I think punishment should be equivalent to the offense committed. So trying to defend the juvenile, as I said now, 76% of the crime committed by juveniles is in the age group of 16 and 18. Why 16? I would say even a 15-year-old juvenile, if he's committing a heinous offense, should be tried under the IPC.
Geeta Luthra, would you want to come in here?
Yes, I think this argument slightly illogical, though I have great regard for my friend. See, it's not the age. You have to have a cutoff age. The basis of a cutoff age, I mean, it can be 10, it can be 12, it can be 8. Why do you have a cutoff age? You have a cutoff age because you have to give time to that child to mature. True, it is in that sense, in layman's language, an unpardonable offense. But we are not looking as laymen. We are looking as lawyers, as jurists, and psychologists and psychiatrists. Is there, and my learned friend is saying deterrence, the extreme of deterrence is eye for eye. The extreme of retributive justice is an eye for an eye, a life for a life. We don't do that because criminology has developed far more. And although there is a possibility that legal reform could look at that way, that people are maturing earlier, therefore between 16 and 18, we should be looking at punishing them as normal adults. But the question is, if you don't do the study, when your law reform comes and you don't do that study in a proper manner, and you don't involve psychologists, psychiatrists, and you just can't go by NCB, data, because it may just be an indicator that that's an age where people are doing such offenses, but are they reformative? Can you change this person? Does
But Geeta ji,
society
fact
ever
is, in
really-
this particular case, Geeta ji, sorry to interrupt you here, but in this particular case, it is the Supreme Court that asked the Juvenile Justice Board to do an evaluation, a
because
re-evaluation
that's
actually.
the law.
Are you
That is
telling me
now
that the
the
Juvenile
law.
Justice Board will just
I'm
yeah,
going
exactly. So I'm
behind
saying,
the law.
are you having me
Ma'am,
believe
I
that they
am
will
going
do the
behind
job
the
without
law.
psychiatrists on board?
No, I'm going behind the
The
law.
juvenile board has the people from NGO,
me
they have
a
a psychiatrist,
second.
they have a judge.
One
So,
minute.
in fact,
Abha,
Geeta Luthra may remember that the Ashiana rape case where a minister's son was involved, they tried to get the
We're
age changed. They are taking a benefit of saying that adult be treated as a juvenile and let them go off with a lighter punishment. We cannot, as lawyers or even as accountable citizens, we cannot see to it that people are misusing the law because you are trying to say we believe in reformation.
see, when you make a law, you have to have data, you have to have research. This law was changed in a knee-jerk manner without actually examining the entire position. Supreme Court has no option but to say that the Juvenile Justice Board has to look at it because that is the law unless there is a challenge to it. Now, question here is that when this law was amended, and that's the duty of Parliament, how much studying went into changing that age? So ultimately, under the Child Rights Act and under UN conventions, you are talking of a person being underage if he is below 18. It is possible that today children are maturing at a younger age, and therefore you could have the parameter change. But question here is, have you done those studies enough? Have you looked at it? You've done a far-reaching reform. You have to weigh this, that of course it's heinous. So we can't just say
But data suggests these juveniles are they are committing the.
I was completing a sentence. Sorry. So all I'm saying is that what we are trying to say is that it can't just be based on data. You can't say 31,000, 28,000. That's not data. Data has to be, there has to be an analysis ultimately.
But that data is taken in a very systematic manner. And when the cases we are seeing, be it Ashiana, be it Nirbhaya, be it the Hyderabad rape, when we are seeing that juveniles, if they can commit, no, my learned friend, my issue is that if you can commit such an heinous offense, why should you get the protection that you are a child? No, it cannot be. And then you are motivating others also to commit crime and get off because
what
you know
if
that the punishment is
8-year-old
right.
commits it? What if your 8-year-old commits it? It's still heinous. No. Will you make the same argument?
You have not made 8-year-old.
It's heinous. No, Geeta ji, it's heinous. It's heinous.
It is not the law.
But for an 8-year-old, you still think of that 8-year-old as a child.
Cannot even rape a woman. An 8-year-old cannot rape a woman. I'm sure 8-year-old would not be able to do it also. So let us not go by conjectures. Law goes by facts.
Let me get in.
16 to 18 has been made. See what the law says.
Let me get in a caller. Ladies, just let me get in a caller. We have Kangana on the phone line. Let's listen into the voice of the citizen. Kangana, please go ahead, please. Just give me a minute, ladies. Let's hear from the... Yeah, Kangana, please go ahead.
Yeah, hi. I have seen this debate, and also I'm knowing all this background of the case. So if it is juvenile or not, crime is crime. See, as a citizen, I am also having similar age child, and I have undergone all the trauma. We should treat crime as a crime, not based on age. See, how can a child like 14 years or 13 years can do such a heinous crime just for postponing an exam, just to get a small benefit? It is not his life, end of his life, right? How can a child take such an heinous crime action? I think there is a bigger thing we have to think socially, family, everybody has to support, and we have to treat this kid, whatever is there, whoever is there, we have to treat him as an adult and conduct the trial based on adult rules only, adult policies only, and law. It is not that juvenile. Always we are giving credit or discount to every child
any
like
case,
this. Yeah, sorry.
In any case, the 16-year-old is now a 20 or a 21-year-old because the case has dragged on for 5 long years. The boy's father has gone from one court to another, challenging the Juvenile Justice Board's assessment that this was someone who knew exactly what they were doing and therefore should be tried as an adult. The High Court, Punjab and Haryana High Court, had ruled that he needs to be tried as an adult. The parents then took the matter to the Supreme Court. Let me go across to Hyderabad because I'm just going to request our guests to stay on because our reporter from Hyderabad, Shaumit, is joining us. This is where that 16-year-old was gang raped by 5 men. Shaumit, you're joining us on the broadcast. They take this girl all over town, they gang rape her. 4 are juveniles, I believe, and 1 was an adult. Only 1 of them was an adult. As far as the Hyderabad, in this case, in the case of the Ryan International School in Gurgaon, the CBI was very clear that the boy has to be treated and therefore tried as an adult. What about the Hyderabad police? Because they have been facing the same dilemma, the same debate and the same question as well.
Well, Shreya, after 16 amendment, it's very clear that if the accused, the JJLs, especially the CCLs who are involved in the crime, if they are involved in the heinous crime and if they are committed, then the teeth, the bones and the maturity will be considered by a psychiatrist, and later, that will be evaluated by the Juvenile Justice Board, and then they will recommend to the concerned court to treat them as, minors or the adults, basically. So even in the Hyderabad city, there were actually, 5 minors. One was not there at present while gang rape was reported, and he actually got down from the car. But in the Innova car, she was gang raped by the 5, initially 4 minors and 1 adult, 1 major, and then later, they have arrested all these accused after, media and public outrage. And till then, actually the incident happened on the May 20th, and till June 1st, they didn't even register a gang rape FIR, and sections like 376D and Section 5 and 6 of POCSO was not included. After, it reported by the media on 3rd of June, they have, altered the sections from, outrage of modesty to the gang rape, and later they have started the investigation, and they've been seen, since the beginning, safeguarding the AIMML's son, who was the actual person who started the crime, committing crime, and later he got down from the car. Then later, she was gang raped. However, we can say that, in this case, after, police have filed a charge sheet, they have also, JJB has also taken that into the consideration because of the heinous crime. She was gang raped, and they have evaluated only the 4 minors, and because they were booked under gang rape, and all these minors who are 16 and 17 years old, they have been their mental situation was evaluated, the teeth and bone growth was evaluated, and finally, JJB has taken call that these 4 minors, the juveniles conflict with law, should be treated as the adults. And the AIMML's son, when actually he comes into the matter, he was not booked under the criminal conspiracy. He was not booked under the gang rape. Also, police stated that, the victim, her girl, didn't give any consent or the statement to the police stating that he was involved in the gang rape. But however, we can state that only, gang rape sections were booked under 5, including 4 minors, and these 4 minors have been evaluated and they will be treated as adults now. But, when it comes to the other minor, who is also 16 years old and very mature enough, and, he knows what he was doing, and even videos were out at that time, but, he was not evaluated because he was not included in the heinous crime. And, when we have spoke to the Juvenile Justice Board, they stated that Section 15 of Juvenile Justice Board doesn't allow them to evaluate this minor because he's not involved in the heinous crime.
Okay, we leave it there, Shaumit. So the Juvenile Justice Board more or less is concluding that of the 4 minors, 3 will be tried as adults, is what you're telling us. Quickly going across to our callers who are joining us. Dev is calling us from Noida. Dev, please go ahead.
Hi, ma'am. First of all, congratulations to you and your team for taking up this story. I actually had a question for the lawyers that are on your panel tonight. So in Chhattisgarh, Bhilai, last year there was an incident of a first-year student of college who was murdered cold-blooded at the side of the river. Her name was Ankita Mandal. She was strangled to death and beaten with a stone, and we could not recognize her face. She was my sister. And that boy, he was 17 years old, and my sister was 16. He was not tried as a juvenile. He was tried as an adult. But he was just few months away from his 18th birthday. Now they've said that he's going to be in jail for 20-something years. But I do not feel that justice has been served. Why is it that urban and rural, the way of law, why is it, used differently?
Okay, Dev. I'm sorry for your loss. I don't know what to say. Thank you for calling us. I'm sorry for your loss, and I will put that question to our lawyers on the panel. You feel that justice wasn't served, and justice definitely wasn't served. Who would want to respond to this? Abha Singh, would you want to come in here? You'll have to unmute yourself. Abhaji, you'll have to unmute yourself.
Yeah, I've unmuted myself. What specifically she was asking, I couldn't catch on.
Her sister was murdered in cold blood. Sister was 16, the boy was 17. He was tried as an adult, but she says even after being tried as an adult, she doesn't feel that justice was delivered or justice was served because he'll walk out after the age of 21.
That I would say is a travesty of justice, because very true, if you walk out at 21, but now if it is going to be treated as an heinous offense, that is what they are saying, that if a juvenile commits crime between 16 to 18, he would be tried under the IPC, where at least punishment would be at least minimum 7 years. Because if it was under the earlier law, it would be at 21, he would go scot-free, like the Nirbhaya rapist. At 21, he walked out. But then again, in criminal law, nothing is retrospective. Because the crime which the boy of 17 committed against her sister, at that time this law was not there of heinous, and hence he was let off at 21. But as of now, if any crime is committed and the Juvenile Justice Board certifies it that this needs to be tried under the Indian Penal Code, under the adult law, then the juvenile would not get the benefit of being a juvenile if he commits a heinous offense. So all my sympathies are with her, but then criminal law is not retrospective, and that is why the person was let off. But I would definitely like the local police to keep a track on such juvenile offenders, because my experience as a lawyer tells me that when these people have come out, they have not reformed, but they have come out hardened criminals, and they are committing more crimes.
That point with you, but we have two other callers, so let me quickly speak to them and come to you with Dev's point. Even if the boy is to serve a 20-year imprisonment, even if he is to be behind bars for 20 years, the family will always feel that they have not got justice. I'll come to you with that point. Rahul Mehta is calling us from Ahmedabad. Rahul, please go ahead.
Quick things. I think if you look at the United Kingdom, the law that they have as juvenile age, it actually triggers that most of the youngsters get into organized crime, and they get community activities as an award of punishment. Has it helped United Kingdom to really reduce the rate of crime from juveniles? Answer is no. I think the basic confusion we are having here is we are talking about juvenile as a perspective to age. If you shift that from a focus of the impact of crime and say that, okay, whomsoever it is, you will award the punishment based on the age or the relevance of the recipient, and on the heinity of the entire crime. Because the moment you add an entire part of juvenile or adult, it goes into a system which is so old that we have, that neither there is corrective processes for the individual to come out cleanly, as our advocates are admitting, nor does it take it to the families to heal. So I think the way to look at it is you treat all of them on the impact of the crime and not as a function of age. Over back to you.
Thank you. Thank you so much, Rahul. You make a good point there. Rajiv is calling us from Bangalore. Rajiv, please go ahead.
I feel is that children and young teenagers, all the way to college-going students, have rights, but with rights come responsibilities. And we need within the legal framework a disciplinary architecture that applies uniformly across the board for all schools and colleges, so that students, teachers are equipped with a legal framework to deal with disciplinary problems. And the last bit I want to say is we need reformatory schools right across the country where children with disciplinary problems can be sent to so that they can be corrected over a 1 or 2 period in such reformatory schools.
Captain Jaispal is calling us from Rohtak. I'm afraid that's the last caller we'll be able to take. Captain Jaispal, please go ahead.
Good evening, Shreya. I'm very kind of you. You see, what has happened to the kids is they have lost their bearing. Parents are not giving them that touch that they need. What they watch on TV, and they get an impression that jhoot, frame, dhokha will succeed. We shall be able to outwit each one of them. And so there is a negative cycle of negativity has moved into motion. The kids are not getting it. Firstly, the entire responsibility goes to the parents. Their mobile discipline, their personal touch to their kids, knowing their psychology, keeping them on this holy earth, knowing fully well that all the pillars of the democracy have collapsed. So the responsibility has increased. And thank you very much. You have been kind.
Thank you, Captain Jaispal, for calling us. You know, I'm going to give the last word to Shashikant ji, who's been a former DGP of Punjab. Shashikant ji, you heard from Dev. I still cannot get, I still cannot get over the pain that she held in her voice. She said, and I should have maybe cross-questioned her as well, but she said that even, my 16-year-old sister is clobbered to death by a 17-year-old. Yes, he's treated as an adult, and that is how he's tried, but he'll walk out after some time. He'll walk out in 15 years, 20 years. But I still feel that justice has not been delivered. She's not wrong.
I fully agree with her. In this case, that's why I said that mental age or whatever this numerical age is one thing. Look at the state of his criminal mind. The person who has done it, that shows that he's irresponsible. He gets into rage and all those things. He needs the strictest possible punishment. Okay, reformation and everything is there, should be there. But to my point is only one, age has nothing to do with this kind of thing, that what punishment should be given. Law per se, that law and punishment, age should not be sort of, they should not be put in the parallel of this thing. Yes, it's the heinous. If it's heinous, it is heinous. And if the person needs to have a sort of normally whatever the crime is given, they need to give the strictest possible punishment, because this is simply not done. Here is the need for deterrence. Thank you.
Okay. That means that age simply cannot be a defense. It cannot be a defense in the 2017 Ryan case. It cannot be the defense either in the Hyderabad gang rape case as well. Abha Singh, Meenu Pada, Shashikant ji and Geeta Luthra, thank you very much for joining us on this broadcast. The news just came in. We thought it was something important that should be discussed. The debate will continue, of course, not just in this case, but even in the case of Hyderabad and other crimes that are committed by minors. Can age really be a defense? No, it cannot. On that note, I'm slipping into a quick break on the show. There's more coming up on the other side. Do stay with us.